It's May 6, 2026. Welcome to yes-to-hell-with.com. Up to this point, we've discussed the structure of prosecution and why most Americans lose before they ever understand the process that they are entering. The courtroom itself creates pressure, the judge, the prosecutor, the formality, the entire process itself. Most people walk in an intimidated state and begin reacting emotionally rather than responding deliberately. Now, understand this clearly. A real court moves quickly. You will not have 10 uninterrupted minutes to explain yourself. You only have seconds, seconds to respond, seconds to preserve your composure, seconds to avoid conceding something you do not fully understand. So the purpose of this example is not to teach argument, it's to demonstrate structure, restraint, and composure under pressure. Pay attention not merely to the words, but to the posture, because that distinction changes everything. Here is the courtroom scene. We've got a defendant and a judge. The defendant is standing calmly after the case is called. Judge, state your name for the record. Good morning, Your Honor. My name is John Doe. Are you represented by counsel today? No, Your Honor. I'm appearing pro per. Very well. You've been charged with this crime. How do you plead? Your Honor, before entering a plea, I would respectfully request clarification regarding the basis of the charge so that I can respond appropriately and accurately. Sir, this is a simple question. You need to enter a plea. Your Honor, I am not refusing to proceed. I'm attempting to ensure that my response is informed rather than presumptive. Could the court identify the authority underlying the charge being asserted in this matter? The authority is the law, sir, of this state. You are charged under the applicable statute. Respectfully, Your Honor, I understand that a statute is being referenced. I'm attempting to understand the specific basis upon which this proceeding is moving forward so that I may respond accurately within that framework. Sir, the court is not going to debate legal theory with you this morning. Your Honor, I'm not attempting to debate, I'm attempting to clarify. Respectfully, I'm asking whether the court is asserting jurisdiction in this matter and how that jurisdiction has been established in this specific case. Sir, this court has jurisdiction over criminal matters occurring within the county. Thank you, Your Honor. Additionally, I would respectfully ask how I am being classified within this proceeding and under what legal definition that classification arises. You are the defendant in a criminal case, sir. Yes, Your Honor. I would also respectfully ask who the claimant is in this matter and what specific injury or violation is being alleged. The Commonwealth is the prosecuting authority, sir. The alleged violation is contained in the charging instrument. Thank you, Your Honor. And finally, I would respectfully ask what specific obligation is being asserted against me and how it is being applied in this case. Sir, the obligation is compliance with the law as charged under the statute. Yes, Your Honor. My concern is simply that without identifying these foundational elements clearly, any response I provide would be based upon presumption rather than understanding. I'm not refusing to proceed. I'm requesting clarification so that I may respond accurately within the framework being applied. Your requests are noted for the record, sir. You need to enter a plea. Your Honor, for the record, I maintain that I requested clarification regarding the authority, jurisdiction, status, and obligation associated with this proceeding prior to entering a plea. However, in order to proceed and without waiving those concerns, I enter a plea of not guilty. Very well, a plea of not guilty will be entered. Now we notice what happened in this case. There was no emotional outburst, no yelling, no argument, no attempt to overpower the court. And equally important, the defendant did not immediately surrender his position through blind assumption. Instead, he remained calm. He attempted to clarify. He preserved the record, and then he proceeded. Now, understand this carefully. This does not mean the case is won. It does not mean that the judge suddenly agrees. And it does not stop the process. The value is much more practical than that. The defendant maintained composure. He avoided panic. He avoided emotional reaction. And he avoided blindly conceding what he did not understand. That matters because most people lose control of themselves long before they lose the case. The Liberty Dialogues is not about magical words or courtroom theatrics. It's about discipline, sequence, clarity, and composure under pressure. And as always, may truth reign supreme.